This is the fourth talk in a series brought to you by the Foyle Product Liability Sector Focus team. My name is Daniel West. I'm a partner at BLM specialising in product liability claims. I hope you enjoyed the last talk in our series, which was presented by Neil Block QC of 39 Essex Chambers, who spoke about product liability and recall in the UK. I'm going to talk to you about the recent trend for pursuing commercial property damage claims under the Consumer Protection Act, which I will refer to throughout this talk as the CPA. As its name suggests, the CPA's primary purpose is to protect consumers. Part 1 of the Act implemented the Product Liability Directive and introduced a strict liability regime for product liability claims where damage is caused by defects in products. Part 2 created government powers for the regulation of consumer safety. However, lawyers have recently sought to bring claims under Section 41 of the Act which do not relate to consumer losses, but instead relate to commercial property damage. In this talk, we are going to look at how Part 1 of the CPA excludes commercial claims, how Part 2 and Section 41 of the Act potentially introduces a separate cause of action for the sole use of commercial claimants, what the courts have said about claims under Section 41, and possible arguments against using Section 41 for commercial claims. Part 1 of the CPA provides a strict liability regime imposing liability on producers, own branders, and importers of products in the event there is a defect in that product which causes damage. Despite the name of the Act, Part 1 does not mention consumers or seek to define a consumer, and in fact does not mention the types of person who can bring a claim. Indeed, one of the key features of Part 1 is that it does not limit claims to the person who purchased the product, as in contractual claims. Anyone can potentially bring a claim, provided they have suffered either personal injury or property damage. But importantly, Section 5.3 of the Act does limit Part 1 claims to non-commercial claimants, since it provides that potential defendants shall not be liable under the Act for damage to property, which is not of a description of property ordinarily intended for private use, occupation, or consumption, and intended by the person suffering the loss or damage mainly for his own private use, occupation, or consumption. Section 5.3 therefore makes clear that the Act is not intended to provide redress for commercial property damage. And since the only type of damage a business or company could suffer is commercial property damage, it is clear that Part 1 is not intended to benefit such businesses or companies or commercial claimants generally. Of course, commercial claimants have other avenues available to them, such as claims in contract and in negligence, but in recent years we have also started to see a reliance by commercial claimants on Section 41 of the CPA. Section 41 is nothing new. It has been part of the CPA and has gone relatively unnoticed since the Act's inception in the 80s, but lawyers appear to have spotted its potential usefulness in the last 10 years or so. As mentioned, Part 2 of the Act deals with consumer safety. Section 11 provides that the Secretary of State has the power to make safety regulations for the purposes of securing that goods are safe. Section 12 makes it a criminal offence to breach such a safety regulation. The Secretary of State has made a wide range of safety regulations by virtue of the powers granted by the CPA. These safety regulations normally focus on a specific type of product such as cosmetics, electrical equipment, gas appliances, and toys, to name but a few. Importantly for our purposes, later in the Act, Section 41 goes further and provides that an obligation imposed by safety regulations shall be a duty owed to any person who may be affected by a contravention of the obligation, and a contravention of any such obligation shall be actionable accordingly. Breaking that down, what Section 41 appears to be saying is that if Party A is affected, meaning it has sustained a loss, because Party B has breached a safety regulation, then Party A can bring a civil action against Party B, and this is regardless of the type of damage caused by the breach. Section 5.3, which is, as we have seen, excludes commercial property damage, appears to be limited to claims under Part 1 of the Act and does not appear to apply to Section 41. Section 41 has been pleaded in a number of reported cases, including Howmet and Economy Devices, Good Life Food and Hall Fire Protection, and Stoke-on-Trent College and Pelican Rouge Coffee Solutions Group. In each case, the safety regulation which was said to have been breached was the Electrical Equipment Safety Regulations 1994, which I will return to in a moment. Perhaps surprisingly, it does not appear that any of the defendants in these cases sought to argue that the claimant could not make a claim in respect of a commercial property damage under Section 41. Rather, it appears to have been common ground between the parties that the claimant could bring such a claim. Out of the 3 cases, Howmet and Goodlife were appealed, but neither appeal related to the use of Section 41, but instead related to separate issues. Hence, a subsequent court would not be bound by either Howmet or Goodlife, because it appears it was merely assumed that the Section 41 claims were valid, rather than it having been determined by the Court of Appeal. Finally, Section 41 was also considered more recently in the case of Wilson and Biko, but that was a case where the claimant was in fact a consumer who had hoped to utilise Section 41 in order to avoid some of the pitfalls under Part 1 of the Act. The court said that a non-commercial claimant is limited to pursuing a claim under Part 1. Again, there appears to have been an assumption on the part of the court that a commercial claimant could pursue a claim under Section 41, but there was no determination on this point because the court did not need to make such a determination. It may seem surprising to some that an act which was clearly enacted to protect consumers would also create a separate cause of action for the sole use of commercial claimants. Indeed, if we look at the CPA in more detail, we can see that the Act on its own does not create such a cause of action. In particular, Section 19 of the Act provides that for the purposes of making safety regulations, the term safe means that there should be no risk or a minimum level of risk that such goods will cause death or personal injury. Section 19 does not mention property damage, so it would appear that the CPA only empowers the Secretary of State to make safety regulations dealing with risks to the person and not risks to the property. However, contrary to what appears to have been empowered by the CPA, the electrical equipment safety regulations, which were the safety regulations said to have been breached in each of the cases I've mentioned, expands the definition of the term safe beyond what is stated in the CPA to include a risk of damage to property. This was because the regulations essentially served 2 masters and had to also comply with the Electrical Equipment Directive, which did not relate to product liability, but instead related to the harmonisation of laws relating to electrical equipment. Hence, it is only because of a relatively unique feature of the electrical equipment safety regulations that there can be a claim for damage to property under Section 41 at all. Hence, the regulations appear to have created a cause of action which can only be used by commercial claimants despite arising from an act enacted for the benefit of non-commercial claimants, and which can only be used in respect of specific products, that is, products for which the relevant safety regulations expand the definition of the term safe to include damage to property. It is difficult to see any logical justification for such an approach. Hence, it would not be surprising if we start to see future defendants start to question claims pursued under Section 41 of the CPA. For example, a defendant could argue that the electrical equipment safety regulations are not, in fact, safety regulations for the purposes of a Section 41 claim, because they go beyond the CPA's definition of a safety regulations, or at least they are not safety regulations to the extent they deal with the risk of property damage. Unless and until there is a proper consideration of this issue, uncertainty will remain. That brings me to the end of this talk, which I hope you have found useful. The next talk in our series will be presented by Joanna Fulton of Burness-Paull. Joanna will discuss the topic of no-fault redress schemes for COVID-19 vaccines. Thank you for listening.